So welcome everybody. Welcome to Innovation Guelph Presents Toolkit Tuesday. Today's session is all about intellectual property, or what we commonly call it IP. So what is IP and what do we do with it? Luckily, Tom Nagy is here today to teach us about patents and trademarks, trade secrets, copyright, industrial designs, and more. What are they? How do you register them? Why are they so important? And Tom's going to also dig around through IP myths and provide usable, actionable takeaway information to allow you to make short-term tactical decisions and some longer-term strategic decisions about both the IP that you currently have or that you're thinking about building into your business in the future. So before I introduce Tom, I have a little bit of housekeeping. Today's session will be recorded and it will be posted publicly on Innovation Guelph's YouTube channel. So we ask that you turn off your mics for the presentation. And if you have any questions, you can type them in the chat box below. Jordan will be monitoring that conversation and she's going to pose your questions to Tom when we have the right moment to do so, or of course, during the last 30 minutes of the presentation when we have the open Q&A component of today's presentation. So, as I mentioned earlier to some of you on the call, to experience today's presentation in American Sign Language, please do pin or spotlight Tom and both the interpreters, Jeanette and Krista, to the top of your gallery. And in addition, anyone in the session today can access the Zoom closed caption function by clicking on the closed captioning option at the bottom of your screen. And I haven't introduced myself yet, so hello, everybody. I'm Nikki Campo. I'm a program manager at Innovation Guelph. And I'm really happy that you guys have decided to join us here today for the lunch hour to learn with us and to sit through this wonderful hour and a half with Tom. I would like to take a moment to thank our sponsors, ISU Corp, Morexis, OKR Financial, Reese Informatica, Invest in Guelph, and BDO. We thank them and are so grateful for all their generosity and support in everything that we do at Innovation Guelph. But also, in addition, Sign Language Interpreting Associates of Ottawa, we sincerely thank you for providing the ASL translation at these monthly Toolkit Tuesday sessions. So, a little bit about Tom. So the presenter today is Tom Nagy. Tom is an Innovation Guelph mentor and IP specialist. I'm not going to read all of Tom's background to you. I'm sure you've seen it on our advertisements, but Tom has plenty of experience in different IP trademark portfolios and has done great extensive work in the area of IP. So I'll let Tom introduce himself a bit when he starts his presentation. So for many of you on the call, you know who Innovation Guelph is, you know what we do, but just briefly, for those of you who may not know about Innovation Guelph, well, just a really quick background. Innovation Guelph is one of 17 regional innovation centers in Ontario, and while we're located in Guelph, we do serve the entire region of southwestern Ontario. We have one national program, so while we do most of our work relatively close by, we actually have clients in BC all the way to Nova Scotia. So, and clients all throughout Ontario. And we're really proud of the work we do with our clients. We do a lot of support, guidance, mentorship through multiple different stages of business, right from startup to scaling enterprises. But enough about me and us and what we do. I want to get you started on the IP lesson today. So Tom, over to you.
Thank you very much, Mickey. That's a wonderful introduction. I'm Tom Nagy, as Mickey said, and I'm going to start by sharing my presentation here in PowerPoint. Does everyone see the title page there? Yep, looks good. Okay. So I'm going to do a little bit of an introduction of myself that'll come up in one slide's time. And but first, I just want to say thank you, everyone, for coming. This is a Toolkit Tuesday, Introduction to IP. What is it, and what do I do with it? So We've got about an hour, and I want to be cognizant of the time, so we're going to try and get through this material as we can. And if you have questions, then I would ask that you please post them in the chat. I believe Jordan is going to be handling the questions, and we'll be compiling them. If you have something that pertains directly to the slide, something that I may have misspoken or that needs clarification, then I'll try and answer that right away. Otherwise, I'll ask that we hold bigger questions up until the end of the presentation. And please keep in mind that I can't directly offer legal advice for your specific situation, because usually it requires a bit of a delve to figure out what the best IP strategy is. However, I can certainly speak about principles and guiding strategies. So just be aware that I won't be able to do personalized consultation for all 30 or 50 or however many folks show up. So let's get on with it. Who am I? You've seen my picture there, and there it is again, Tom Nagy. I'm an engineer with a decade of software development and management experience at RIM. That was starting from back in the last century, actually. And after that, I wore a number of hats and ended up as the IP manager at Arion Labs, which was bought by FLIR. That's in the north end of Waterloo. Around the same time, I started an IP consultancy, which I still have outside of the IG world. And now we've got dozens of clients and advisees through word of mouth. And I've also landed here at IG, and I'm very happy to be an IP specialist at IG. IG IP, that kind of flows nicely. So our topics for today are IP and its value. Then we're going to talk about the different forms of IP. Then we're going to look at best practices, top myths. That's always kind of the fun one. And then we're going to throw it open for a Q&A. I think we've got about a half hour booked for that. I'm certainly happy to stick around a little bit longer if the questions keep coming. So let's dig right into it. What is IP? Well, the World IP Organization, or WIPO, says that it's the property right to protect intangible creations of human intellect. And that's a very dense definition. There are a lot of things to unpack in there. There's a question of what is a property right, and we'll be talking about this throughout the presentation. Often you hear, oh, intellectual property, it's not real property because it can be duplicated. Well, that's not what a property right is. A property right is the ability to exclude someone or to govern the use of something. It doesn't mean that you own or can walk away with something. So a property right to protect intangible creations, I think that's fairly clear, of human intellect. And there are three aspects here that are commonly conflated. First of all, the actual intellectual creation, the underlying idea, the invention, the piece of music that's been composed, that is one element. And then there are rights that are attached to that. For instance, if you compose something, you have moral rights, you have copyright in that work, you have some element of control and ability to exclude others from doing things to it. And then the third part that's conflated is the actual regime. So how do patents work? How do trademarks or copyright work? So these are three very separate concepts: the underlying creation, the rights that arise from that, and then the entire mess of patent and trademark offices and paperwork and litigation and all of that that goes along with it. And we commonly bundle all of that into the concept of IP, but just be aware that those are three very different things. we're going to be touching on all three of those aspects in this presentation. So what makes up IP? Well, people's ideas, plans, customer lists, branding, designs, anything that's a creation of the human intellect, as the WIPO definition says. Products of your work which may be useful for your business, but which aren't directly tangible objects. So I keep coming back to the customer lists that are listed there. People often don't think of customer lists as IP, when in fact they're fundamentally something that you work on. They're something that if they were to fall into competitors' hands would be very detrimental for your business. Ideas or inventions that answer who, what, when, where, why, and how for your business. And then also down here, I've listed literature, artistic works and performances, recordings, scientific discoveries. These are all legitimately elements of human, creations of human intellect, but we're not really going to be discussing these in this presentation. We're primarily going to be talking about other aspects of IP, but just be aware that the idea of what is IP, it's quite broad. So what is the value of IP? What is the value of registering IP? Well, first of all, it's a deterrent to competition. It forms a barrier to entry for other firms who want to enter into that same line of business or the same area of work. If you own the IP to something, then other firms will have a more difficult time competing with you. It's a strong disincentive to theft or fraud because if you get into this person said, that person said kind of an argument, then that can be difficult to assess as to did someone steal this IP or not. But if it is registered or properly, the proper bookkeeping is done, then that makes it much more difficult to steal or defraud someone of their products of human creation. Revenue from sale, licensing, or assignment of IP rights. Those are a very tangible aspect, a very tangible form of valuation of IP. And we're actually going to be looking at how you value IP a little bit later in the presentation. And then there's also its value as a corporate asset. So there's valuation for debt or equity offering, and different banks or venture capital companies may look to patents and trademarks as a sign of how much your enterprise may be worth. And if you are looking to sell your business, then the valuation of your patents and trademarks and copyrights would very much play a role in that buyout decision. Now, another aspect is countering infringement claims from competitors. So if, for instance, you build something in a fairly complex and heavily populated field, then presumably there will be competitors who have patents covering some of what you may have done. But if you have IP as well, then you can cross-license with your competitors, and you can reduce the playing field by basically saying, you know what, maybe we're going to infringe on these 2 patents of yours. Well, we notice you're infringing on these 2 patents of ours. So let's horse trade and agree we're not going to sue one another. That's really what a license is. It's an agreement that you're not going to sue someone. And so by cross-licensing, you're basically protecting yourself, and the other companies protecting themselves, and everyone else in the industry is now at a disadvantage to the 2 of you. You've reduced the playing field. And finally, it's a public demonstration of R&D and industry leadership, being able to show that you have patents and trademarks gives customers confidence in your leadership in that particular area of industry, and perhaps gives some customers a sense of your potential longevity in the business, that you're not going to be wiped away as soon as a larger competitor decides to enter into that field. So the primary forms of legally recognized IP. Once again, there are many, many different kinds of intellectual property that exist, but there are specific registration regimes set up, and the primary ones for that are patents, trademarks, trade secrets, copyrights, and industrial design registrations. I'm going to be giving the last two a bit of a short shrift in this presentation so that we can focus on the first three, which are generally the most important for industrial and commercial uses. If you have questions about copyrights or industrial design registration, I'm happy to answer them. And they can definitely form part of an IP strategy for many companies. I keep getting blipped here. So do we have any questions, Jordan? I can't actually see the chat as I'm presenting, so I'll ask you to just please interrupt me if there are questions that I need to be answering.
Yep, we're good so far.
Sounds great. Thank you. So, without further ado, there we go. Patents. So, what is a patent? And we're going to start with patents and then go on into trademarks and trade secrets. I like to start with patents because it's sort of the big elephant in the room with all of these. It has the most onerous registration regime, and when people talk about the cost of IP, they're generally referring to the cost of patenting their invention. So we'll start there. It's an exclusive right to an invention, which must have novelty, which means it must be new. And in the parlance of the trade and in legalese, we contrast novelty with anticipation. We say that this other piece of, or this other invention, or this other piece of what's called prior art anticipated your invention if it is not novel. There must be inventiveness, must be inventive. I think that speaks for itself. And the contrast is obviousness. Now, I shouldn't say it speaks for itself. There are huge areas of law that devote themselves to what is novelty and what is inventiveness. And we'll touch on that in a bit. And the third point is there must be utility. It must be useful. So coming back to that first line there, it's an exclusive right to an invention. So you can't patent an idea. You can't patent a design. You can't patent a play or a piece of music. It's an invention. And what you get is an exclusive right. And in the legal parlance, exclusive is exactly what that word implies. It allows you to exclude others from that area. For some reason, the slideshow keeps clicking away here. What rights does a patent confer? So the patent allows the patentee the exclusive right to make, use, sell, or import the invention as claimed. And that means, again, the exclusive right, it allows you to prevent others from making, using, selling, or importing the invention. Now, the way this is worded, it doesn't make it 100% clear, but this is a good point for me to emphasize. It does not necessarily confer onto you the right to make or use what's in the patent. And the reason for that is there can be many, many overlapping patents that cover similar areas. So for instance, if someone has a patent on the wheel and you have a patent on a way of improving the rim of the wheel, well, you can't necessarily make a wheel with your special rim unless you have a license to the wheel patent itself. So what you can do is, if you have patented the improvement to the wheel, is you can prevent others from making, using, selling, or importing your aspect of that invention. So this is an important point. Patents are jurisdictional. A Canadian patent only grants patent rights within Canada under Canadian patent law. If you want to be able to sue someone for infringement in the United States, you must have a US patent. And countries and jurisdictions are very territorial about giving or giving away patent rights. So historically, very few countries will accede to other jurisdictions. One notable exception is the European Patent Court and the European Patent Office, which has been in the works for many decades now as they've tried to sort out their territorial issues around patent rights. But certainly Canada will only recognize Canadian patents. The US will only recognize American patents for as far as granting you patent rights. However, foreign patents may be recognized for priority dates. So if you file a US patent, then you can, in certain circumstances, file a Canadian patent later and claim priority to that American patent. Because really the biggest thing in a patent as far as what's protecting you is the priority date, which is the date at which you have disclosed that particular invention. And whoever files first in a first to file jurisdiction, which is what we have in North America and much of the world, whoever files first has that initial date. They have the first rights to a patent. So recognizing a priority date is very important. Foreign patents may be recognized as prior art. So if there is an American patent which covers substantially the same thing as what you are trying to patent, then your patent will be denied as being anticipated or not novel in light of that other patent. And it can also be a source of reasoning to help allow a substantially similar Canadian patent application. So there are ways where different patent offices, again, they're very territorial, but they will admit that maybe other patent offices have good ideas some of the time too. And so if your patent is filed in multiple jurisdictions, then often there are treaties in place that say that if one of them grants it, then the other will look at the reasoning and say, okay, yeah, we're persuaded that that's pretty good. We'll grant that here too. You may hear the term the patent prosecution highway, and that's actually the name of a whole bunch of treaties between different countries that allow reasoning to be passed from one jurisdiction to another jurisdiction to help speed up filings and to help speed up examinations. So what can be patented? Well, the specifics vary from country to country, but in general, products, machines, processes or methods, compositions, such as chemical compounds, or any improvement on any of these could be considered patentable. And I put the question down, do you have something that could be patented? And that's something for you to look within yourself and within your business and see if any of these sorts of things, processes and methods are often disregarded because people think, oh, that's not a thing. But in fact, the way that you produce a chemical compound or the way that a system operates, those methods may well be patentable. So the inverse question, what cannot be patented? Specifics vary from country to country, but in general, basic ideas or concepts or discoveries, scientific principles or mathematical theorems, methods of medical treatment or surgery. That's an interesting caveat that most countries put in. And the reason for that is that a patent right must be licensed in order for it to be usable. And a method of medical treatment may often be invoked in an emergency situation, and there may not be time to acquire a license for the use of that patent. So many countries, Canada included, exclude methods of medical treatment or surgery. However, that doesn't mean that machines or other sorts of devices that aid with medical treatment or surgery, and certainly pharmaceuticals that are involved in medical treatment, those are certainly patentable. But for instance, a new way of administering CPR would not be patentable. Higher life forms, that's a whole other kettle of fish, so to speak. If anyone's interested, you can Google the Harvard mouse case, and that you will have more than enough information on that particular aspect. And if anyone has issues with patenting higher life forms, please talk to me afterwards. Forms of energy and features of solely intellectual or aesthetic significance. We'll talk a little bit later about design registrations, but something that doesn't have utility in itself can't be patented. And finally, printed matter is generally not patentable unless you've invented a new way of printing or a new type of printed matter. But something that's simply been put into a book, that's not on its own patentable.
We have a question, Tom.
Yeah.
So Leah is asking, I've heard that patents can be very expensive. Could you provide general information on how much these cost? And how can you tell if this is worth exploring for your business based on your business's financials?
That is a great question, and it's covered in an upcoming slide. So I will ask you to hold on to that one, please. And if you don't get the answer that you're looking for, then please ask me afterwards.
Great. And then we have one more follow-up question from Kevin. Does printed matter include 3D printing?
So that's a really interesting question. The invention that underlies something that you have 3D printed is patentable, and you can obtain a patent right on it. But simply 3D printing something does not make it patentable. The underlying invention that you have 3D printed might be. You might be able to claim a copyright, although that perhaps in the 3D printing code. You might be able to claim an industrial design registration for the aesthetic aspect of something that's 3D printed. So in and of itself, there is no 3D printing registration system, but different aspects of it can be parceled off. So let's ask the question here, why do patents exist? Patents are public documents which must disclose a complete invention, And in exchange for making an invention public, the inventor receives a kind of monopoly right on the invention for a limited term, usually 20 years. And this is referred to as the bargain theory of patents. Originally, patents were just something that a king would grant you on a piece of paper. If you went and were good friends with the king, then and were able to convince him, I should say also the queen, could confer those rights. If you went to the regent or monarch, then they would be able to confer a patent right to you. And so over time, it became recognized that this kind of a bargain forms the intellectual underpinning of why we continue to have that today. It's enshrined in the US Constitution. It's not in the Canadian one, and that's a kind of a strange thing. You might think patents are kind of this arcane thing, but in fact, they do make an appearance in the original American US Constitution. And so the idea is normally you would keep your invention a secret to help with your business, to give you a competitive advantage. And by giving you an official monopoly on the invention, the government is asking you to disclose in exchange the invention so that further generations can be helped by your work and knowledge by having these patents public. So what is in a patent? Well, there are 4 sections, and if you go Googling, you will find many, many examples of patents, but they will have these 3 primary sections: a description, which is, as I say, the meat of the patent, and it shows all the relevant details of the invention. And you have to, what's called reduce it to practice. You have to be able to show in your patent description how you are actually going to be able to get from your problem statement to your end result. It has to be a recipe that someone who is knowledgeable about this area can follow. You're not crafting this for a layperson necessarily. You're crafting it to be able to instruct someone who is in the industry to follow your recipe and come up with the solution that you have proposed. And that's all contained within the description. Then there are patent claims, and this is the area of subject matter taken from the description and supported by the description, which you are claiming a monopoly on. You're saying, here, I've laid bare my invention to the public. I'm asking the patent office to grant me this area of monopoly. This is what I claim is novel and inventive and useful. And I want to take that for myself for 20 years in exchange for having divulged the company jewels. And then there are figures, which the drawings that aid in understanding the material. And these can often be as important as the written description when it comes to deciphering what exactly has been disclosed. Because, as they say, a picture is worth 1,000 words. And if something is shown in a drawing in a patent application, that can often change the course of whether that particular aspect can be considered to have been disclosed. Then there are a number of formal sections. I don't want to delve too deeply into this. The inventors, the title, the abstract, and so on. Inventorship is a very important aspect of it, but it's something that's more, it's not a conceptual area. It's more of something that needs to be tracked down, and we can certainly talk about that if you have specific questions about inventorship.
Another question for you regarding patents, Tom.
Yep.
This one's from Christy. Do you need to file a PCT patent 12 months after provisional or final patent? So
we'll talk about the PCT shortly. a PCT application, maybe I'll take that detour right now. There's a patent cooperation treaty, and that is an application that's often considered an international application. And the way that works is you file a PCT application, and 30 months after your priority date, you get to decide, or 31 in some cases, depends on the country, but for many jurisdictions it's 30 months after your initial filing, you get to decide which countries you actually want to file in. It doesn't take the place of a national filing. It just provides an entry point into multiple national filings. And so that must be filed before your national entry. However, if you file a national patent somewhere, that could be considered to be a priority document for a PCT application, excuse me. There are a number of caveats to that, and I'm happy to cover that off in the Q&A section afterwards. So if that doesn't entirely answer the question, then please bring that back up. I'm going to continue on here. How is an invention turned into a patent? Well, you have the initial invention conception, and you disclose that with an invention disclosure statement usually. That's what your agent or patent lawyer will want to see, a full disclosure of when did you invent this and who was involved and how does it work, what else is out there that you're aware of. And then they will prepare a patent application for you. That patent application is filed before the patent office, and then the office reviews that application and conducts prior art searches. Then there are written arguments exchanged between the applicant and the patent office, and then the office makes a determination on the patentability of it. That yellow section, the center line there, that's called the examination phase of the application. And this whole aspect is called prosecution. Often we refer to, and just colloquially, we talk about prosecution being you sue someone. That's actually litigation. Prosecution is the movement forward of an application through a process. So this whole chart is what we call patent prosecution. And so once the patent is granted and the rights come into effect, then you can enforce those rights by suing or licensing, and then eventually your patent expires. So what kinds of patents are there? We're getting into the meat of this here. There are provisional patent applications, and these are inexpensive placeholders that give you a priority date. It gives you a stake in the ground that you invented this thing on this date, but it doesn't actually confer any patent rights or protections on its own. It expires within a year, and it's never actually examined directly by the patent office. It just forms a basis for a subsequent application. And the initial idea was that provisional patent applications were created so that you can take a year and build together venture capital to come up with a business case and financing for filing an actual utility patent, which is the kind of patent that we've been talking about. And then there are patent cooperation treaty applications, the PCT, which is an international application. So we're getting into a lot more of the nitty-gritty here, but the general idea is you can file a provisional patent application for not very much money. It doesn't protect you, but it provides you with a starting point. And then once you've proven out the invention, then you can file a full utility application within 1 year. So how much does it cost? Well, it depends. A simple provisional application with only a few figures in it may not cost very much money at all. And the actual patent office filing fee currently for a micro entity, which is basically, as you might expect, a very small company, it's somewhere it's below $100. The drafting time for a lawyer or agent, that will cost a certain amount of money. You may be looking at a couple of $1,000s for that, and then there's usually some work involved in actually filing it. You could expect a very simple provisional to cost well under $5,000. A complex family of applications filed in many jurisdictions via PCT applications may cost upwards of $100,000 over its lifetime. That's really the upper end. If someone quotes you $100,000 on a patent application, I would ask for a second opinion. This is really the high end, and most of them, for a US application, which is where most people end up filing, they will spend between $20,000 and $30,000 from the very beginning of the process to the very end of the process. That's if you use a traditional law firm and you end up paying full fees on everything. The cost can be quite a bit less if you use if there are other things at play. So then how much is my patent worth if you're going to be spending that much money? There are three general areas of how we evaluate the value of a patent. The first is a cost-based valuation. So how much did it cost you to develop that IP? How much R&D time did you put into it? And then how much did it cost to acquire the patent rights to it? The second way that people will often value IP is based on the revenue. So how much can you get for selling or licensing this IP in the market? And there are, this isn't just guesswork. There are a lot of tools available, both actual software-based and cloud-based systems that can help you value patents, as well as intellectual frameworks that you can walk through for that. And the final method of valuation is how much are your competitors disadvantaged by your owning this IP? So if you have a sense that it's costing your competitors $100,000 a year to try and work around your patent, that gives you an excellent starting point for how much that patent could be worth. So that covers off the patent section. I'm going to zoom into trademarks now. If you have patent questions, I'm going to ask that we save those for the chat at the end, please. So what is a trademark now? We're switching gears here. A trademark is a word or words or a design or some combination of these used in association with the goods and services of an organization. As the word trademark itself implies, it's something that's used in the everyday trade of your business. So it's a recognition of the mind share built by your company. And it's essentially a product of your marketing and your sales that you have built up in the public, this mind share of what is a BlackBerry, for instance. We all know when you say, oh yeah, I've got a BlackBerry in my pocket, we assume you're not talking about the fruit. We assume you're talking about the particular brand of cell phone or mobile device. And that is the mind share that BlackBerry has built through their marketing and through their sales and through delivering products. So your trademark must be unique. It can't sound or look similar to another mark. Also, it cannot be descriptive. So if you are selling something, for instance, scissors, then you can't have a trademark on the term metal scissors, because that's an entirely descriptive phrase that people could use to refer to any kind of metal scissors that are on the market, not just yours. And you want to stay away from descriptive phrases as well, because if it turns out that your scissors are not actually made of metal, then that would be considered to be deceptive or fraudulent. So, like patents, trademarks must be filed separately in each jurisdiction. A Canadian trademark does not protect you in the US, and vice versa. And in fact, you can carve up territorial areas for trademarks. This is usually done through a litigation process that says, well, this company has established a foothold in Eastern Canada with this particular name, and this other company using the same name is based just in Vancouver, and so they can coexist. And they can also coexist even in the same geographic area if they have a very, very different set of products and services. So the goods and services of an organization determine where you can have that trademark. So for instance, could I have a company called McDonald's Grass Cutting? Yes, I probably could, because no one would associate that with the burger chain McDonald's unless I go out of my way to advertise with big golden arches and put a Big Mac in my grass cutting logo for some reason. So no one will confuse my McDonald's grass cutting with, the McDonald's Burger Company. But if I wanted to come up with, for those of you who've seen the movie Coming to America, McDowell's Burgers, that would be probably considered to be infringing on the trademark, because it sounds similar enough that people might think that you are actually associated with them. That's something of a minefield that I don't necessarily want to get into, but do I need to register a trademark? Well, here's where things get interesting. Under basic common law in North America, you don't actually need to register a trademark. Your claim will be much stronger if you do register a trademark. The process there is simply you fill out a trademark application and you send it to the trademark office. They examine it and make sure that it's not overlapping with anyone else's trademark. And once they agree that, yeah, there's no overlap, then they will send it back to you and say, okay, you've got a trademark. So if you don't register the trademark and someone begins to, you believe, infringe on it, then you could always take that to court and say, well, these people stole my name. And you could be found to actually have a common law trademark, but you will have to prove your use and prove that you are entitled to a trademark during litigation, which is far more onerous. Whereas there's a presumption that you own that trademark if it is registered. So Canada and the US are first to use jurisdictions, and that it is different in some other jurisdictions. But your first use of that trademark does confer additional priority to you. So an asserted but unregistered trademark under common law may be marked with the superscript TM, while registered trademarks may be marked with the circle R. So when you see TM, that basically just means that the company or individual is asserting that what they have marked is their trademark. They're asserting that potentially with a lot of proof and benefit of use, or perhaps with none. You don't necessarily know. If they are marking it with a circle R, that means that it has been examined by the trademark office, and the trademark office has conferred the trademark to them. So why register my trademark? I think I've covered most of this here. There's a strong claim of validity because the office has examined it. You will be able to litigate under common law or under statute, and that's a difference that it's a fairly big difference in terms of how you can litigate. It's maybe getting into an arcane area, and I'll press on here. If anyone's really interested in that, then ask me afterwards. The ability to renew the trademark indefinitely given continued use, and ease of licensing. This is perhaps the biggest point if you're not going to be litigating. The ease of licensing and sale and assignment, and indeed the valuation of the trademark as IP, is much easier if you have registered it and if the trademark office says, yes, you own this as a piece of IP, instead of you just asserting it as a common law trademark. Once again, how much does it cost? Well, it depends. And I hate it when people get cagey about pricing, but unfortunately, this is IP is one of those areas where the cost, the time and energy that goes into it can vary over orders of magnitude from the simplest case to the most difficult case. And it's really something where someone needs to sit down and look at the totality of the situation. So you need to file in each jurisdiction, so Canada, the US, perhaps Europe, wherever you want the trademark, and each trademark class or area of doing business carries an additional fee in general. So if you want to include the legal time, the filing fees, and then the trademark office fees, I would count on a couple of $1,000s per jurisdiction in order to do the filing. That is a total swag, not knowing anything about your particular situation, but that's perhaps a good rule of thumb to go by.
Question, Tom. So Kevin's wondering, if you register your trademark, are you required to use the R icon?
You are not required to mark it. However, if you don't mark your trademark, then it's more difficult to prove that the other person knowingly infringed on your trademark. So giving notice is an important part of the whole trademark assertion and litigation process. And marking something appropriately gives notice that is something that's yours. And then the other company can't say, oh, we didn't know McDonald's was a brand of burger. Sorry. Now, you will want to consult with someone before using the circle R, because I have had it on good authority that in some areas in the US, marking something with circle R when it is in fact not properly registered is, it does carry significant penalties, because they don't want people marking everything with circle R when it hasn't been registered. So there have been a couple of cases where people thought that they had a registered trademark, but in fact didn't. And there were penalties associated with that. So some lawyers will suggest always mark it with TM, which is the weaker, but still you're asserting this as a trademark marking. So I'm not a lawyer myself, so I'm not going to give you legal advice on that point. I will simply say that marking your trademarks is important. Marking with TM is generally well regarded everywhere. Marking with an R is stronger, but I would consult with someone to make sure that you have the right to do so.
Awesome, thanks. And just a quick time check for everyone. We're about 2 minutes to 1. So if you can, please hold your remaining questions until the end. Thanks.
Okay. Well, we've got about 10 minutes left in the presentation here. So trade secrets. And so this is sort of the third area that I'm going to focus on in the presentation. What is a trade secret? Any confidential information or IP which may provide you with a competitive advantage. So examples would include software, including the underlying algorithms, any aspect of the software, in fact, that provides an advantage, business methods, client lists or ways of identifying new clients, ways of doing business, company plans or strategies. So marketing or sales plans, product development plans. So product roadmaps, for instance. Legal strategies, including IP development or protection, or for instance, that you are considering suing another company. Information contained within a product which can't be discerned through lawful means. So something embedded within, if you have a black box product, then what's inside there, if it's not obvious how something is accomplishing what it is accomplishing, that may well be a trade secret. Secret formulae, compositions, recipes, and anything where if you wrote it down on a piece of paper, you would label it confidential. That's kind of the ultimate sniff test. If there's something where you wrote it down and you would not want a competitor finding that piece of paper, you would consider that to be a trade secret. Well, how do I protect a trade secret? Really, it's just process. There is no way, I shouldn't say there is no way, there are now just starting to be areas of law that allow you to sue for trade secret theft. But generally speaking, your recourse would be against the person who stole the trade secret from you, not necessarily the world at large. So if you have a formerly trusted person who has taken the Coke recipe from you and published it on the internet, well, the Coke recipe is not protected by patent or by anything else. It's protected as a trade secret. So if they publish it online and someone else starts to manufacture a beverage that suspiciously tastes a lot like Coke, you may not have recourse as the Coke company against those other companies. You would only have recourse against the person who took the recipe from you. And perhaps you might be able to sue them into the ground and take every penny that they have, but presumably that's worth a lot less than the billions of dollars a year that Coke makes off of its product. So the way that you protect a trade secret, label it. Ensure that everyone who comes across it is aware that it is a trade secret. Hide it, so make it difficult to come across accidentally. And then protect that particular document. Only allow access to people who need to know. Ensure that employee contracts cover trade secrets, and ensure that any outside disclosure is under a non-disclosure agreement. I put down there is no registration regime, and litigation can be difficult. It's easier to protect it than to recover it. So moving on, other forms of IP. Copyright, we'll just quickly go through this. It protects the expression of the ideas, not the idea itself. So the right of creators over use and distribution of their literary and artistic creations. And this can include books, films, musical compositions, software, and technical documentation. And copyright vests at the time of creation with either the creator or the employer, and that is a question of law depending on the relationship between the creator and their employer. And we can go into that a little bit further if anyone's interested, but basically it is just the expression of the idea. So the actual words used, not the underlying idea itself. if a piece of software embodies a patentable invention, the copyright only covers the way you talk about that in the software. It doesn't cover the actual invention. Industrial design registration, it's also known as trade dress or design patent registration. It protects just the ornamental or aesthetic aspect of an article. I've put a couple of examples down here. The very familiar Coke bottle. That shape is ornamental, and it's almost like a trademark in that people associate that shape of bottle with you and with your company. People look at that device on the right and they say, oh, that looks like a BlackBerry. So it's not a functional aspect of the article. It is purely ornamental. And in fact, it can't have a useful aspect to it. And industrial design registrations are actually fairly inexpensive to do, and there's not a lot of examination that goes on with them. They're a great way to protect the shape and dress of your product. So what IP do you have? Consider inventions or artistic creations, the mind share that you have built in your market. So talking to your customers or potential customers, advertising, going to trade shows, putting your product out there onto supermarket shelves. Those are all ways you build mind share, and that's IP. The ideas in the heads of your people, so your employees or contractors, that's also very much the IP that you have spent time and money building. And so understand what your priorities are in your business. What is your business about? What should I be protecting and why? What benefit does protecting this particular thing have? Often a highly innovative business will just spin off IP like there's no tomorrow. The question is, you can't be spending millions of dollars a year patenting unless you're IBM. So what aspects of the IP that you're generating do you want to protect? And what is that going to do for your business? That's what you have to understand. I often counsel clients that, you got into this business that you're doing not to generate, patent applications. You want to be running your own business. How can your patent or trademark or IP advisor really help you achieve your business goals without deterring or distracting you from the business that you are in? How can we make it a business goal or a business asset for you without railroading you or taking you off course? So protect ideas as soon as it makes sense and is feasible to do so. We talked a bit about priority dates, and that's really an important aspect in all of IP. The first people to come up with something and file it get the patent rights on that invention. So as soon as it makes sense to do so, and only if it makes sense to do so, file for IP protection. And create a process that tracks IP in your organization. So when you have some sort of a dream up session or a what we call IP mining session, then make sure that that's all documented and tracked, and you figure out how you're going to protect it. When you do some sort of visioning about an upcoming product and you've got 8 million ideas, those could all go into a quick patent application, possibly. So make sure that when people are developing the IP in your organization, that you have a process that's able to take advantage and protect that IP. Avoid disclosing ideas without protection in place. NDAs, NDAs, NDAs. Make sure that when you talk to potential clients, when you talk to suppliers, when you talk to anybody outside of your organization, then make sure you have a non-disclosure agreement in place. Even if you have a mentor or someone else that you're bouncing ideas off of. I know the IG agreements do cover intellectual property, but make sure that if you're bouncing ideas off of someone, there's an NDA in place. You don't want to accidentally give away some of your hard-earned, hard-worked-for IP. And file provisional patent applications whenever possible, before you have a major disclosure event, before you do a presentation, before you go to a trade show, before you speak to clients or suppliers, file a provisional patent application. It's a very low cost, comparatively, way of protecting your invention. And filing a provisional patent application, even though it doesn't in itself confer protection, it does give you the priority date, and it allows you to say patent pending. And that can be a very important aspect. Consider IP in your contract. So make sure your employee contracts, software licenses, your sales agreements, make sure that whatever IP you have or could have is covered off in those contracts. And your IG mentor will be able to speak on either on those, or will have resources, to be able to help you with that. Just very quickly, I'm going to go through a couple of top IP myths, and then we'll throw it open for questions. Myth number one, an issued patent allows me to practice my invention. Nope. As I mentioned earlier, a patent allows you to prevent others from practicing the invention, from making, using, selling, or importing your invention. And it's only the invention as claimed. The patent right is encompassed within the claims, not within the description. Most patents improve on or overlap with other IP, and you may need to license or purchase other IP to practice your invention. So keep that in mind. And often the invention as claimed in the patent is not the product that you end up selling or commercializing. Sometimes the two end up being very different. So be cognizant of the fact that over the course of the filing, you end up perhaps with a different patent from what you are from your product. Myth number two, I came up with a great idea and I can patent or copyright it. Well, not necessarily. You can patent an invention that comes from the idea. You can copyright the expression of an idea, but the idea itself may be difficult to protect. So you could consider marking and protecting it as a trade secret if the underlying idea is what you really want to protect. So the two examples I have here, an electric motorized doggy-doo scoop, it's a great idea, but any patent would have to spell out how you actually implement this invention. What is the inventive aspect of this? And how does it work? And then young girl overcomes great odds and defeats many ninjas. Great idea for a movie. I may or may not go and see it, but it's too general an idea to copyright. You would need to actually, you would have to have an expression of this idea, and that is what could be copyrighted. Final myth, you can't use my business name, it's copyrighted. And this is something, engineers have this problem with tech movies all the time, where they'll be pointing out the flaws. And if you have an engineer in your family, you've probably seen how annoying it is when we point out all the physics problems in a Marvel superhero film. Your business name may be your trademark. It's unlikely that it's copyrighted. I mentioned the movie Coming to America. There's Coming to America 2, which is not a great film, I will say, but is available. I think it's on Prime or Netflix right now. They actually make an error regarding copyright and trademark, and they refer to something that should be a trademark as a copyright. And this is very common. A copyright covers literary or artistic expression. The trademark covers a word, phrase, or design used to represent your product, service, or other aspect of your business. And so those two are very different things from an IP perspective, but they're very often confused in the colloquial world. So that covers off the presentation as such. I think we started just about an hour ago, and so we're now into the Q&A section. Jordan, I'm not sure, do you want to curate this, or should I be looking at the chat as well?
I can curate it for you, no problem.
Great, okay.
Awesome. So our first question, which I believe you touched on, but please re-clarify for us, recipes can be considered a trade secret.
Absolutely. Recipes very much can be considered a trade secret. And if you should really mark that it's a trade secret. As I mentioned in that section, process is where your greatest protection strength comes from. Mark it as a trade secret. Make sure that only the people who really need to know about it. And whenever you speak about it with someone, then make sure that that arrangement is covered by a contract, an employee contract, or an NDA, or some sort of intellectual property agreement.
Awesome, thank you. Next question from Patricia. Question regarding the use of typefaces and logos. I understand that some typefaces offered in apps such as Canva are actually protected and hence cannot be used in logos.
That's something that will be governed by the actual license of the typeface, I believe. That's something where we'd have to take a look at the specific situation. It's quite possible that you may inadvertently incorporate elements that are themselves under copyright protection or some other protection. And so I would defer to the license agreement in place for that particular typeface. But you are correct that it's possible to accidentally incorporate someone else's IP into your filing. And that would not be great.
Great, thanks. Question from Christian. How do you find companies that are infringing on a patent? Are there organizations that enforce patents and or find patent infringing companies?
So no, the government relies on you to police the situation. You will need to, if you find someone in the course of your business who is infringing on your patent, or that you believe is infringing on your patent, then you should contact legal counsel, and usually the first step is to send a cease and desist notice, just to make sure that they're aware that you believe that they are infringing on your patent. Someone is not legally infringing on your patent until that has been adjudicated by a court. So you can assert that they are committing patent infringement, but they can say, well, no, we're not. We don't believe we are, and then take that to court. Or the two of you can agree that yes, in fact, that has happened, and they will pay you $1 per item license fee, and then you agree that you are now going to license that patent to them. It is essentially up to you to police that. there are companies you can hire to police your IP for you. They're really not something that most people need to bother themselves with. In the general course of your trade, you will come across the people who are infringing on your patent, if there are any. And your customers will probably let you know if there is some sort of infringement happening, because they'll say, oh, these other folks over here are giving me a much better deal on exactly the same thing. So you will build up through customer or competitive intelligence a list of people who are doing the same sort of thing as you, and then it's up to you to kind of look into whether they are infringing.
Awesome, thank you. Judy is wondering, would you trademark or copyright a logo?
So a logo should be trademarked. Yeah, that's short answer. Yes.
Thank you.
Yes.
And Leah is looking for a suggestion. What would be the best IP for website design or systems used within the website? The best type of IP?
So that's a multi-layered question. The actual layout of a website and the content within it are subject to copyright. So as I was saying, it's the expression of ideas. So the way you've laid out something on a page and the text that you've used, the choice of words, if you put blog articles up, then the contents of your blog are automatically under copyright. And this is something I didn't go into great detail, but copyright vests at the moment of creation. You don't actually have to register for copyright. As soon as you've created it, you or your employer, depending on the agreement in place, own that copyright. And so all you have to do is keep backups and proof of your creation. Some people talk about mailing something to yourself to prove the date of creation, because you get the stamp from the post office. You don't necessarily have to go to those extents. I mean, putting something into a revision control system that has timestamps on it, and often even just the file history in your operating system can help track down the date of creation. As far as trademarking, if you have a logo or something that is thereby directly connected with your business, that part could be trademarked. But the actual website itself would likely fall under copyright. Great,
thank you. Circling back to the question we had about PCT earlier in the presentation for some clarification. So Christy says, to be clear, we filed provisional 22 months ago and the final 11 months ago. Are they still within the time frame to file PCT?
So your PCT application has to be filed within 12 months of the priority date. So not knowing all of the details of the circumstances here, it sounds like you're probably past the initial priority date. There's no reason that you couldn't file a PCT application. However, you will need to make sure that your earlier filings don't fall under prior art, because they will now not be considered priority documents directly related to your PCT application. And you have the other document it may be too late to file, given not knowing the subject matter area and not knowing what's included in the provisional, what's included in the other filing, and what you're putting into the PCT. It's hard to give a definitive answer. That's something where certainly that's something that I could look at as part of, a mentoring arrangement. If you have questions about that, or if you have patent counsel right now, then they would be happy to look into that, I'm sure.
Awesome, thanks. Aaron is wondering, what if I built a trade secret and I'm pursued for infringement, specifically relating to software?
So you've created something and it's been held as a trade secret. In order for that scenario to actually come to pass, what would have to happen is someone else would have to have patented what you are building, and that patent would have to go through examination, and that patent would be issued. What you are doing underlying all of that as a trade, you've been keeping that as a trade secret. So either you didn't know that they were filing that patent, or you simply didn't assert your trade secret during that process to try and knock out their patent application. So given that as the backdrop, there are what are called prior user rights in pretty much every jurisdiction. And these relate to the ability of someone to continue using an invention that they invented before the priority date of someone else's patent application, but which they did not proceed to use, or they did not proceed to patent themselves. So prior user rights actually depend on the jurisdiction. And this is not that's a very long preamble to a not very helpful answer, but it depends on the jurisdiction that you're talking about. In North America, there are fairly constrained prior user rights, which basically say you can continue doing what you have been doing if you can prove that you were doing it at the time of the priority date of the other application. So it wasn't public knowledge. You said that it was a trade secret. So it doesn't knock out the other person's patent application. If what you had been doing had been public knowledge at the time that they filed their application, then you can simply say, well, it was in the public, and so that prior art can be asserted against their actual patent and could be used to invalidate their patent. But in this particular situation, because it wasn't public knowledge, you would have presumably prior user rights. As I say, in North America, that's constrained to continuing to do what you are doing. In other jurisdictions, notably France, I believe, has very broad prior user rights within their country, which allow you to do a lot more. That if you actually have documented proof of your use or invention of that invention, then you can commercialize it and make changes to it and so on. That right is very constrained in North America. It depends on the jurisdiction, and it depends on what you are doing with that IP.
Great, thank you. And this is the last question we received, and I'll cut it off after this question, and then I'll ask Mickey to jump in with our wrap up. So last question is, you have a secret sauce that has been disclosed already in another function. Is the only way to protect the recipe now through an NDA and a strong agreement?
Could you read that one again?
For sure.
Please?
So, if you have a secret sauce that has been disclosed already in another function, is the only way to protect it now through an NDA and a strong agreement?
So if it's been disclosed already, we use the word, so terminology, we use the word disclosure to talk about making something publicly available. And if the secret sauce is already publicly available, then You can try to protect it through an NDA or strong agreements. It likely would not be patentable. Having said that, that's something where you would have to look at the specifics of the situation, because if it's a very different function, there is the potential for perhaps embellishing it and then actually protecting it with a patent at that point. But if that's not the case, then you can try to protect it through NDA and a strong agreement. But if it's already out in the public, then that may be difficult to assert. Again, it depends on the specifics, and happy to speak with you through as an IG mentor about that situation.
Awesome, thank you. And that wraps up our Q&A. Over to Mickey. You're muted, Mickey.
Sorry. Figures. Thank you so much, Tom, and thank you everybody for joining today. Really appreciate it as well. Right before you disappear, Jordan's gonna post a feedback form link in the chat. We'd really appreciate it if you could click on it and give us your feedback on today's session as well. Please leave some comments about what you would like to see in the future for these Toolkit Tuesday sessions. So future sessions, April 20th will be our next Toolkit Tuesday session. We'd love for you to attend then. So thank you again to all of our sponsors, to Jordan, to Tom, to our SLEO interpreters today. Many thanks to all of you for joining us, and we really hope you do come back again soon. So April 20th, mark it on your calendars. The topic will be released soon. Take care. Have a great afternoon.